All right, good afternoon, everyone, and welcome to this webinar training titled Quick Q&A Session for General Practitioners. My name is Catherine Pembroke. I'm the Administrative and Training Coordinator for the Maryland State Commission on Criminal Sentencing Policy. Now, some might recall that we held some general guidelines training sessions back in September where we reviewed general guidelines rules and some recent updates. So we thought it'd be helpful just to follow up with a quick 30-minute Q&A question and answer session, which gives you all an opportunity to ask any guidelines related questions that you may have and receive answers from our staff in real time. So with that said, I have several of my colleagues here with me today, our program analyst, Sarah Bowles, and our research analyst, Kathy Sanchez. And to get us started and a little warmed up, we did compile some of the more commonly asked guidelines and Maryland automated guideline system related questions from general practitioners, such as state's attorneys, parole and probation agents, and defense attorneys who calculate the sentencing guidelines. Now, these questions we will be reviewing. They will cover a range of topics, including sentencing guidelines eligibility, specific areas of guidelines calculation, and then some considerations to keep in mind regarding the Maryland automated guideline system. Now, even though we already have some questions ready to review, if we get to a topic that may be relevant to any question that you have, please feel free to raise your hand in the Zoom panel. We can then call your name. You can feel free to unmute yourself and ask any question, or alternatively, you can submit any questions that you have through the chat box throughout the course of the presentation, and our staff will reply to you. We do encourage that everyone submit their question to the entire group, just so everyone can benefit from seeing the question and answer. But if you don't feel comfortable doing that, that's fine. If you could just send a direct message to either Sarah Bowles or Kathy Sanchez so that we can reply to you. All right, so to get started, let's look at a common question regarding guidelines eligibility. And the question is, do Maryland sentencing guidelines apply to misdemeanors? Now, this is a question that we've been receiving with more and more frequency, really over the course of the last few months here. So I did want to clarify that yes, the sentencing guidelines apply to both guidelines eligible misdemeanors and felonies that are prosecuted in a circuit court. So they are not limited to solely felonies prosecuted in a circuit court. They also include guidelines eligible misdemeanors. So let's take a look at the broader scope of the sentencing guidelines here. So as I just mentioned, the Maryland sentencing guidelines apply to criminal cases that are prosecuted in a circuit court. The sentencing matters that you see here on the left-hand side, these require a guidelines worksheet. We refer to these as guidelines eligible sentencings. So these include circuit court original sentencings, jury trial prayers and appeals from the district court if a pre-sentence investigation is ordered, and any original sentencings adjudicated via a probation before judgment. Now, in addition to original sentencings, given concerns involving crimes of violence, we also collect worksheets for reconsiderations and modifications, and 3-judge panel reviews involving a crime of violence as defined under Criminal Law 14-101, if there is an adjustment made to the original active sentence as a result of that reconsideration or modification or review. Now, guidelines eligible reconsiderations and modifications, they include sentence adjustments imposed pursuant to Maryland Rule 4-345, a Health General 8-507 order, or again, a 3-judge panel review. Now, the sentencing matters that you see listed here on the right-hand side, these are handled by judges in a circuit court, but they are excluded from guidelines coverage. So those, again, are jury trial prayers and appeals from the district court unless a pre-sentence investigation is ordered, crimes that carry no possibility of incarceration, violations of public local laws and municipal ordinances, sentencing hearings in response to a violation of probation, criminal non-support and criminal contempt cases, cases adjudicated in a juvenile court, and then finally, the guidelines do not apply to district court sentencings. Now, we often get guidelines eligibility questions regarding 2 offenses in particular. The first is a violation of Baltimore City Code 59-2, which involves discharging a firearm. Now, even though this particular offense carries the possibility of incarceration, it is still a violation of Baltimore City Code, and therefore it is not a guidelines eligible offense and should not be reflected on the guidelines worksheet. The second offense is reckless driving. So this may often be charged with other motor vehicle related offenses, but since it does not carry the possibility of incarceration, it would be excluded from the guidelines worksheet. Now here's a question pertaining to the calculation of the offense score, specifically the scoring of victim injury. Now, just as a reminder, the offense score is calculated for person offenses only. So those being assault, robbery, as well as weapon-related offenses, those typically involving victims. Now the question is, should non-permanent or permanent victim injury points be scored for offenses involving photographic or video evidence of child pornography? And the answer is that permanent victim injury points should be scored for these offenses. Now, this instruction can be found in our guidelines manual and is intended to apply permanent victim injury points to any offense involving photographic or video evidence of child pornography and is not limited to convictions for the possession, manufacture, or distribution of child pornography. So for instance, this rule may apply in cases involving the following types of offenses if evidence of child pornography is present, that being sexual solicitation of a minor, sextortion, visual and camera surveillance of a private place, obscene matter, prostitution, human trafficking, or electronic harassment. Now, the scoring of permanent victim injury points recognizes that the photographic and video evidence of child pornography often exists in perpetuity, and the victims of these crimes suffer lasting psychological consequences and are re-victimized every time an image is viewed, possessed, or distributed. So again, permanent victim injury points should be scored for these types of offenses. Now, here's another question pertaining to the offense score calculation in general. Now, let's say we have a defendant who's charged with armed robbery, but pleads to robbery. Should weapon presence points still be scored? And the answer is yes. Just to clarify, the judge may include factors known to the judge, even if they are outside of the scope of the convicted offense. So again, for example, if a defendant is charged with armed robbery, pleads to robbery, or if perhaps there's victim injury associated with a weapon-related offense, points may still be awarded for that weapon presence and victim injury, respectively. So here's another question pertaining to the offense score calculation, again, specifically the scoring of weapon presence points. Now, does gasoline or a lighter constitute an explosive as it pertains to weapon presence points? And the answer is no. So these, that being the gasoline or a lighter, they are considered incendiary material and should be treated as a weapon other than a firearm or an explosive. So let's take a look at this definition of explosive for the purposes of assigning weapon presence points in greater detail. Now, in response to multiple inquiries that we received, asking whether the presence of items designed to start a fire, such as gasoline and a lighter, would constitute an explosive as it pertains to the assignment of weapon presence points in Part C of the offense score, the Commission reviewed this issue and decided to clarify the offense score instructions to reference the definitions of explosive and incendiary materials that are provided in Criminal Law Article 4-501. So based on this clarifying language, the presence of gasoline and a lighter would be considered incendiary material and would therefore constitute a weapon other than a firearm and would be awarded 1 point for weapon presence. All right, another question pertaining to the offense score calculation, specifically the scoring of special victim vulnerability. Now, if a victim was known by the defendant to be intoxicated, does this meet the criteria for special victim vulnerability? The short answer is yes, it does. So let's take a look at the factors that are used to determine if a victim is especially vulnerable. So 1 point would be scored for special victim vulnerability if the victim is younger than 11 or 65 years old or older, or if they have a temporary or permanent physical or mental disability, including an individual who is physically or mentally limited in a material way. So examples of a temporary physical or mental limitation include, but are not limited to, instances when the offender knew or should have known the victim was pregnant, unconscious, asleep, or intoxicated. So again, if the victim or the circumstances of the victim meet this criteria, 1 point would be scored for special victim vulnerability. So moving on to the offender score calculation, let's review some of these questions. This is the most common question we receive regarding the scoring of Part A of the offender score. Now, does pretrial supervision constitute criminal justice system involvement for the purposes of scoring Part A? That being the relationship to the criminal justice system when the instant offense occurred. Short answer is no. Generally no. So let's take a look at why that is. Now, an offender should receive 1 point if they are in the criminal justice system. For example, if the defendant is currently on parole, probation, mandatory supervision, etc., as a result of an adjudication of guilt at the time the offense was committed. So criminal justice system involvement, it must be as a result of an adjudication of guilt. So this is why pretrial supervision or the defendant being out on bail generally wouldn't constitute criminal justice system involvement, unless the defendant had been adjudicated guilty of an offense and was on pretrial supervision pending sentencing at the time the instant offense occurred. But again, generally, pretrial supervision does not meet that criminal justice system involvement criteria. So here's another question pertaining to the scoring of Part A of the offender score. This one we've also been receiving with some more frequency lately. So does the sex offender registry constitute criminal justice system involvement for the purposes of scoring Part A? Again, the relationship to the criminal justice system when the instant offense occurred. Now at the commission's, short answer is no. So at the commission's September 17th, 2019 business meeting, this topic was discussed and there was a majority vote against including sex offender registration in Part A's definition of criminal justice supervision involvement. So therefore, if the defendant was on the sex offender registry as a result of an adjudication of guilt at the time the instant offense occurred, as long as there was no other form of supervision taking place, for example, they weren't on parole or probation supervision, 1 point would not be scored for the defendant being on the sex offender registry. Now here's a question pertaining to the scoring of the prior adult criminal record component of the offender score. Now, if a seriousness category changes for an offense, which seriousness category do I use to calculate the prior adult criminal record? And the answer is that the sentencing guidelines and offense seriousness categories in effect at the time of sentencing shall be used to calculate the guidelines. Now, if the state's attorney or defense attorney, if it's determined that the guidelines are different than what they would have been if calculated using the sentencing guidelines and offense seriousness categories in effect on the date of the offense of conviction was committed, the state's attorney or defense counsel may bring that to the attention of the judge as consideration for departure from the guidelines. So let's look at an example. This is related to the impact of recent cannabis penalty changes on the sentencing guidelines. So effective January 1 of this year, the maximum penalty for violations of criminal law 5-602 subsection B1 and 5-603B, that being unlawfully possessed with intent to distribute, manufacture, possess production equipment of cannabis, that penalty decreased from 5 years to 3 years. And accordingly, the commission voted to change the seriousness category from a 4 to a 5. So when calculating the prior adult criminal record, if a defendant's prior criminal history involved this offense, you would use that new and reduced seriousness category of 5, since that is now the seriousness category in effect for this particular offense. So here's a common question we receive pertaining to the overall calculation of the guidelines. Let's say if the indictment includes multiple offenses that were committed over a period of time, should they be treated as one criminal event or multiple criminal events? We get this question, not specifically, but more so, it's more common with theft-related offenses. Maybe there was like a theft scheme that was committed over a period of time, along with specific dates that a theft may have occurred. And the answer is that it really depends on the circumstances of the case, types and dates of offenses that you have for each of those offenses, But let's take a look at some additional guidance that might be helpful here. So earlier this year, additional language was added to the definition of what constitutes a single criminal event for guidelines calculation purposes. So this additional language is noted in red here. This language drew on guidance that was provided by a 2022 Supreme Court opinion. And while it doesn't alter the current guidelines rules, we do hope that adding this additional language provides further guidance to practitioners when determining whether multiple crimes were committed during the course of the same transaction. So to clarify, a single criminal event means one or more crimes that was committed in the course of the same transaction. And in determining whether multiple crimes are committed in the course of the same transaction, the person filling out the guidelines worksheet shall consider whether the crimes were 1, committed close in time in an uninterrupted course of conduct, 2, occur in the same location, and 3, are similar in nature or intertwined, for example, whether they share a common scheme or purpose. Whereas multiple criminal events means that more than one criminal transaction was committed over a period of time. Now, multiple criminal events being sentenced together, they may have occurred on the same date or different dates. But generally, offenses that occur on different dates are almost always considered separate criminal events. So again, it really comes down to the facts and circumstances of the case and the discretion of the worksheet preparer to determine the number of criminal events involved in the sentencing event. So here's another question related to the overall calculation of the guidelines here. Is the multiple victim stacking rule limited to person offenses? So I mentioned earlier those person offenses, those typically involving victims like assault, robbery, as well as weapon-related offenses. But the answer to this question is no. The stacking rule is not solely limited to person offenses. So for example, you could have multiple victims of a theft scheme, and the stacking rule could certainly be applied in that scenario where there were multiple victims of a theft scheme. But let's just review the criteria for the application of the victim stacking rule. So to clarify, there must be a criminal event with multiple distinct victims, and there cannot be more than one seriousness category 1 or 2 offense within that criminal event. And only one convicted offense per distinct victim may be used to calculate the overall guidelines. That's actually a question that I've been receiving with more and more frequency. When people are trying to apply the stacking rule, they may have multiple offenses that pertain to the same victim, and they aren't sure if the stacking rule should be applied to all of those offenses pertaining to the same victim or just one. So the answer, again, only one convicted offense per distinct victim may be used to calculate the overall guidelines. And in that case, the offense that has the highest seriousness category, that would carry the highest upper limit, that is the offense that you would want to flag for that distinct victim. And then finally, only the upper limits of the guidelines would stack when the multiple victim stacking rule is applied. So next, I want to briefly review what constitutes a guidelines compliant sentence, as I think this information is really important to keep in mind during plea discussions and negotiations. So let's start with guidelines compliant sentence. Now, to clarify and review, a sentence is deemed compliant with the guidelines if the guidelines applicable sentence, which is defined as the sum of incarceration, credited time, and home detention time, if that falls within the applicable guidelines range. So generally, suspended time is not considered when determining whether a sentence is compliant. There's one exception involving corrections options, which I'll talk about in a moment. But again, generally, suspended time is not considered when determining if a sentence is compliant. So some people get confused. They think guidelines compliance is based on the total sentence. And that is not necessarily true unless you're factoring corrections options. Again, sum of incarceration, credited time, and home detention time. Now, I also want to note that compliance is calculated by comparing the overall total sentence across all convicted offenses in a sentencing event to the overall guidelines range for that sentencing event. So for example, it's possible that the sentence could exceed the upper guidelines limit for one offense in a sentencing event, fall below the lower limit for a second offense, but that overall sentence, when you're adding it together for both counts, it could still fall within that overall guidelines range for the sentencing event. especially when you're taking into consideration whether those sentences are running concurrently or consecutively. Now, there are a few qualifiers to consider regarding guidelines compliance. The first is that sentences adjudicated pursuant to an MSCCSP binding plea agreement are deemed guidelines compliant. Now, binding pleas are three-party agreements in which the state and the defense present to the court on the record an agreement that incorporates a specific sentence. Now, effective April 1 of 2021, the MSCCSP narrowed the definition of what constitutes a guidelines compliant plea and adopted language to specify that an MSCCSP binding plea agreement means an agreement to a specific amount of active time, if any, and not merely a sentence cap or range. The court has the discretion to accept or reject the plea, and that agreement becomes binding on the court under Maryland Rule 4-243 subsection C if the court accepts the plea. So let's take that information, let's apply it to a couple of sample sentencing scenarios. Let's say the guidelines for a sentencing event are 2 years to 8 years. The state and the defense present to the court a plea agreement to a sentence range anywhere from probation to 2 years. The court accepts this agreement and sentences the defendant to 3 years, suspend all but 1 year. Is this an MSCCSP binding plea agreement? And the answer is no. So as a reminder, an MSCCSP binding plea agreement for guidelines compliance must involve an agreement to a specific amount of active time, if any, not merely a sentence range or cap. So in this scenario, the court accepted a plea agreement to a sentence range anywhere from probation to 2 years. And this is why it would not constitute an MSCCSP binding plea agreement for guidelines purposes. Let's look at sentencing scenario number 2. So let's say the guidelines for the sentencing event are 1 year to 6 years. The state and the defense present to the court a plea agreement to 5 years, all suspended, with credit for 62 days. The court accepts this agreement and sentences the defendant to 5 years, all suspended, with credit for 62 days. Is this an MSCCSP binding plea agreement? The answer in this scenario is yes. So in this scenario, there was an agreement to a specific amount of active time, that being 0, or in other words, no post-sentence incarceration. Therefore, this would constitute an MSCCSP binding plea agreement. So an additional qualifier regarding guidelines compliance to consider is the role of corrections options. Now, sentences to corrections options programs, for example, drug courts, residential substance abuse treatment, home detention, they are deemed compliant provided that the initial sentence plus any suspended sentence, so essentially the total sentence, if it falls within or above the applicable guidelines range, and the case does not include a crime of violence, child sex abuse, or escape. So this is the exception I mentioned earlier in which suspended time is considered for determining a guidelines compliant sentence. Now, corrections options, they allow judges to utilize a broader range of alternatives to incarceration while still remaining compliant with the sentencing guidelines. Corrections options include home detention, inpatient residential treatment, inpatient drug or alcohol counseling under Health General 8-505 or 507 order, drug court, participation in any problem-solving court, a sentence with required substance abuse treatment for the possession of controlled dangerous substances, work release, or weekend or other discontinuous incarceration. So let's take a look at another hypothetical sentencing scenario. Let's say the overall guidelines range for this sentencing event is 1 year to 3 years. The defendant was sentenced to a 6-year total sentence, all of which was suspended. The defendant was also sentenced to drug court, a corrections option program, as defined under commission criteria. Now, which of the following best describes the sentence imposed? Is the sentence a departure below the guidelines, a departure above the guidelines, or a guidelines compliant sentence? And the answer is that this is a guidelines compliant sentence. So as previously noted, sentences to corrections options programs are compliant provided that the initial sentence plus any suspended sentence falls within or above the applicable guidelines range, and the case does not include crime of violence, child sex abuse, or escape. So in this case, that 6-year total sentence, even though it was fully suspended, given that the defendant was sentenced to drug court, a corrections option program, and that 6-year total sentence falls within or above the overall guidelines of 1 year to 3 years, this is a guidelines compliant sentence. And then finally, the last rule regarding the calculation of guidelines compliance is that sentences in which the offender received credit for time served with no post-sentence incarceration time, and if that amount of credited time exceeds the guidelines range, it's deemed guidelines compliant. So for example, if the guidelines range is probation to 3 months and the sentence is 6 months fully suspended with credit for 100 days, the sentence is still guidelines compliant, even though that credited time exceeds the upper guidelines limit. Now, I want to wrap up by quickly noting 2 points to keep in mind when initiating worksheets in the Maryland Automated Guideline System. This also can apply to the guidelines calculator tool as well. Now, when there are multiple cases being sentenced in front of the same judge on the same day, they constitute one sentencing event. This means that all of those cases should be entered under one MAGS record or guidelines calculator tool record. So in this example, you can see in this screenshot, I have 2 cases. I have one ending in 1122, one ending in 1133. Now, they are a part of the same sentencing event, and therefore they share the same worksheet ID of 140899. Now, to accomplish this and to make sure that those multiple cases are being initiated correctly under one MAGS record, when you go to initiate the worksheet, you would just want to click this Add New button one time. And then you would enter all of the convicted offense information for all cases within the same sentencing event on the List of Offenses tab. The same is true if you were utilizing the guidelines calculator tool. Again, if you have multiple cases being sentenced in front of the same judge on the same day, they're a part of the same sentencing event. So instead of initiating separate worksheets for those unique case numbers, you want to make sure you're entering all of that convicted offense information for all of those unique case numbers under the List of Offenses tab to ensure proper calculation of the overall guidelines. The last thing I want to note is that we have seen an increase in the number of dummy SID numbers that are being entered in MAGS. For example, that could be all 9s or a 1, 2, 3, 4, 5. And while there may be instances in when there is in fact no SID number, for the example, if the defendant has no prior criminal record, they've never been fingerprinted, it is our understanding that the SID number should be available in very few cases. So it's important that the SID number be entered accurately, as we use that field to help link guidelines data to the Department of Public Safety and Correctional Services corrections data. So therefore, we encourage all practitioners to utilize the rap sheet. We've also heard from others that it's available on inmate lookup. Make sure that you're referencing those resources to identify the correct state identification number and to make sure it's entered into MAGS accordingly. All right, so that wraps up our quick Q&A session. I just want to note, if you ever have future questions or any feedback regarding the guidelines or the work of the Sentencing Commission, please feel free to reach out to us either over the phone 301-403-4165 or via email at msccsp@umd.edu.